Start. So far as the finding recorded by the trial court regarding statement of DW1 and DW2 is concerned, they stated that they had no knowledge about the present incident, full stop. DW1 has stated that had such type of incident taken place at the time, date and place of occurrence, he would have information about the same, full stop. Similar statement has been made by DW2, as DW2 runs a grocery shop in the vicinity of place occurrence, full stop. It is not the case of prosecution that at the time of incident, they were aware about the offence committed by the accused persons, full stop. They came to know about the commission of the present offence when PW2 and PW3 reached at the house of the informant and found PW1 in his house in a fit condition, full stop. Therefore, prosecution case cannot be disbelieved only on the basis of the statement of DW1 and DW2, full stop. As far as failure to note the registration number of the concerned Maruti van by PW3 is concerned, it is clear that he was not aware about the commission of the present offence, as accused persons were known to him, full stop. He simply saw that the accused persons took the victim in the vehicle in question on the pretext of accident of victim's father, full stop. Thus, the submission made by the learned counsel for the appellant in this regard is not acceptable, and the finding recorded by the trial court on this point is also not liable to be interfered with, full stop, para. The trial court has not found proved the offence under section 366 IPC against the accused appellant on the ground that the victim was not recovered, therefore, it is not clear as to whether the essential ingredients to constitute offence under section 366 IPC were attracted in the present matter or not, full stop. The finding of the trial court for the offence under section 363 IPC is clear and based on the evidence available on record, full stop. Victim was aged about 15 years at the time of occurrence, and this fact has been proved by the prosecution beyond reasonable doubt, full stop. No interference is required in the finding of the trial court on this point, as the same is correct, full stop. Since victim girl was minor at the time of incident, necessary ingredients to constitute offence under section 363 IPC is fully attracted in the present matter, full stop. The trial court has rightly held guilty to the accused appellant for committing the present offence under section 363 IPC, full stop, para. Now the court comes to the quantum of sentence for the offence under section 363 IPC. Awarding sentence is always a difficult task which requires balancing of various considerations, full stop. In the present matter, maximum sentence imposed upon the accused appellant is of 5 years and a fine of rupees 5,000, full stop. Submission of the learned counsel for the appellant is that out of the maximum sentence imposed upon him, the accused appellant has served out about 3 years sentence, comma, hence a lenient view in the matter be taken, full stop, para. Having heard the learned counsel for the parties, comma, in our opinion, comma, the appeal should be allowed, full stop. Certain facts are not in dispute, full stop. The father of the applicant who was in service died in harness in March 1987, and for the first time, comma, the application was made by the applicant after more than 4 years, that is in September, comma, 1991, full stop. The family thus survived for more than 4 years after the death of the applicant's father, full stop. Even at the time, comma, the applicant under the relevant guidelines could not have been appointed and hence relaxation was prayed, full stop. It is no doubt true that the case of the applicant was favorably considered by the departments and recommendation was made, but it has also come on record that in March 1996 a decision was taken by the authorities not to give appointment to the applicant on compassionate ground, full stop. From the affidavit in reply filed by the authorities in the High Court, as also from the finding of the learned single judge, comma, it is clear that the applicant had knowledge about rejection of his application in 1996 itself, full stop. Nothing was done by the applicant against the said decision, full stop. Considerable period elapsed, and only in 1999, when there was some interdepartmental communication and administrative officer informed the chief engineer via a letter dated 8th June 1999 that the applicant could not be appointed on compassionate ground, that the applicant woke up and filed a writ petition in the High Court, full stop, para. It is also pertinent to note that the letter of 1999 itself recites that the case of the applicant for compassionate appointment was considered and the prayer had already been turned down by the administrative department, and the said fact had been communicated to the office of the chief engineer, full stop.